the new criminal laws which have now come into effect across the country. And for more perspective on this, we're being joined, in fact, by a special guest. With us live now is a senior advocate and Rajya Sabha Member of Parliament of the Bharatiya Janata Party, Mahesh Jethmalani. Mahesh Jethmalani is, of course, going to help decode the laws for us. Mr. Jethmalani, thank you very much for being with us today. Can you please explain for our viewers these laws? Because, of course, for the layman, this has come as a bit of a surprise. We'd like you to help decode and explain the changes and these new laws for our viewers today.
See, there are two issues. One is of substantive law, right? Substantive law is what are the offences in this country. Those were originally covered by the Indian Penal Code, and now that Indian Penal Code has been replaced by the Bharatiya Nyaya Sanhita. Now, the shift is that, the main shift is that many offences which were really belonging to a colonial era in this first law, right, the Nyaya Sanhita, these laws have been changed to bring it in line with modern independent India's needs. So, for instance, the law of sedition was a law which basically protected the interest of the colonial masters, right? So, it was an offence, for instance, to excite disaffection against the government of the day. That was the definition of sedition, which the Supreme Court stayed. Now, sedition is no longer an offence. Now, it is an offence to advocate secessionism, insurrection, and all activities against the Indian state. The offence of sedition, which was against the government of the day, has now been replaced by a new offence, which proscribes any action which undermines the integrity or unity of the Indian state or promotes secessionism and subversive activities, and it calls for insurrection or revolution against the state, the Indian state. That's one shift, right? The other shift in the Nyaya Sanhita is that it has been found that offences against women and children have increased largely. So the Sanhita now introduces a separate chapter which didn't happen in the Indian Penal Code, right? Probably because the old Indian Penal Code depended upon English morality in the 1860s when the Indian Penal Code was passed, Victorian morality, where, at that time women didn't even have the right to vote, right? So independent India has now seen that there's there's a lot of violence, as you know, starting with Nirbhaya, right? That there's been a lot of violence and sexual offence cases against women and children, including trafficking of children. So a separate chapter has been introduced in the Sanhita specifically for the protection of women and children and punishment of offences against them. Now, this is basically a broad summary of the Sanhita. The Criminal Procedure Code, the second law, has been replaced by the Bharatiya Nagrik Suraksha Sanhita, the BNSS. Now, the thrust over here, right, is that, as you know, there are terrible arrears in this country in criminal cases. The most serious cases have not been completed in the criminal justice system. It's about 15 years of very, very serious offences which have undermined the economy of the nation. Right? Now, as far as the Nagrik Suraksha Sanhita is concerned, the emphasis there is to expedite the entire procedure of the criminal justice system. One is speed, expedition, to eliminate delay. And that is being done, right, by giving timelines for every stage. There are procedures for making FIRs more easily registered by citizens. You can do it electronically now. There are timelines for completion of charge sheets. For further investigation, there are timelines. Then an accused person who files a discharge application, which is the next stage, there's a timeline, right? There's a timeline for trial and there's a timeline for judgment. So the first thing is they've kept timelines for all these things. Second is there's an extensive use of all modern forms of collection of evidence, right? So there's the forensic evidence and its collection is mandated by the Suraksha Sanhita. Right? in fact, a forensic laboratory in each state has to be set up. So to advance methods of forensic investigation. Then audio, video, electronic medium is to be extensively used. The entire search and seizure operation, right? So when you're going to search and seize either money or gold or drugs in the case of narcotics, right? The entire procedure has to be recorded on audio-visual means. So apart from speed, the second thing is what you are doing is you're using modern technology to ensure the integrity of the investigation, the honesty of the investigation. You're trying to eliminate any prosecution unfairness. Now, electronic medium is also used to expedite trials. For instance, you are now permitted to use video conferencing for every witness, whether it's by the prosecution or the defense. A lot of delays under the old system were caused by the absence of witnesses on the trial date. They would refuse to come. Sometimes they wouldn't come because they were out-of-town witnesses. Now all this is being eliminated by use of modern methods of electronic evidence. So witnesses are now allowed to come and depose. Now the third thing is the Indian Evidence Act has been replaced by the Bharatiya Saksha Adhiniyam, right? Now this is meant to basically make admissible. This is the admissibility of evidence. So all electronic evidence now is made up. Electronic evidence is now considered to be documents. Before electronic evidence came into existence, right, there were only two types of evidence, oral and documentary, right? Now there's a third type, electronic evidence. So electronic evidence is now treated as on the same footing. In fact, the definition of document has been expanded to include electronic evidence. So documents now also include all electron outputs from computers, WhatsApp messages on your mobile phones, and so on and so forth. So this is the broad thrust. The broad thrust is to expedite trials, to finish cases soon. Also, another emphasis is that some of the laws have become obsolete in terms of imprisonment. I mean, the Indian Penal Code, for instance, had punishments of a maximum of 500 rupees. Now, this is an 1860 law. So, all these punishments, so far as the fine part was concerned, needed to be revised. Also, you have more, new forms of. So, you have some, some measures for. Some reformation measures as well, right? So social service is a possible sentence that can be imposed in lesser offenses like defamation and all that. Community service. So ultimately, the whole thrust is, as I said, speed, fairness, compassion, reform of offenders.
Absolutely. And, Mr. Jethmalani, the British era sedition law has also now been completely revamped, in fact. Earlier, under the IPC, a person convicted of sedition could get away with a fine. Now, under the Nyaya Sanhita law, there is imprisonment for life prescribed reportedly, in addition to the fine punishment. In fact, it's been made more severe. Do you believe the time was right for such a stringent provision?
Yes, of course. Security of the state is one of the prime thrusts. Sedition was never punishable only with a fine. It was also punishable with imprisonment also. But apart from the definitional change and the shift from offense against the government of the day to offenses against the Indian state, there have been other provisions within the Act, not just sedition, but also offenses under Section 111 of the Nyaya Sanhita, where you had offenses, pertaining to terrorist offenses now are included in the Bharatiya Nyaya Sanhita. So the definition of terrorism is also included in the Nyaya Sanhita. So also, organized criminal activity, such as there are state statutes like Makoka in Maharashtra, where you have organized syndicates, crime syndicates, which perpetrate offenses like, narcotics, extortion, some murder, serious offenses. Now that organized crime has also become a separate class of offenses within the new Bharatiya Nyaya Sanhita, which was not there under the IPC. So this is all a shift on security of the state and as the government has pointed out, protection of citizens from serious criminal menaces like terrorists and organized crime.